Good morning, everyone, and welcome to this LinkedIn Live. My name's Zoe.
I'm Hannah.
And we're both partners in the family law team here at Knights. And we wanted to start off this morning with some fun facts for everybody. So at the moment, there are 3.5 million couples cohabiting in the UK. 47% of the public believe that common law marriage is a thing, despite the fact that it isn't currently. And in 2022, over half of the babies born were born to unmarried parents, which just goes to show the numbers of families and children in particular, who at the moment, the current law doesn't offer a great level of protection to, which is why this consultation is so important.
So yeah, we're here to talk to you today about the recent government consultation, A Fairer Way to End Relationships, which overridingly has been driven by a need to protect those in vulnerable positions within these relationships, and generally aiming towards a more deliberate financial planning within relationships. So as headlines, the consultation covers four areas. The first is that the government is proposing more statutory rules on divorce, clearer statutory rules, so that it will be similar to the current processes. It won't change hugely on the ground, but it does mean that the government's really driving towards making it more accessible, clearer for people to access, because it is a bit convoluted at the moment. Secondly, importantly, binding qualifying nuptial agreements. So the case law has been moving this way for a little while. We're seeing more and more people being held to the terms of their prenups and their postnups, but the government's proposal is that that becomes binding in legislation. So really important to flag with any people that have got prenups who might need them reviewed, brought up to date, and of course anybody considering entering into marriage should really decide and consider whether they could benefit from one. The main highlight of our talk today is number 3, so that's default protections for qualifying cohabitees upon a separation. And number 4 is default protections for those qualifying cohabitees upon death, which actually our colleague Neris Thomas in our private client team did a recording on, and you can find that on the Knights LinkedIn page. As a headline point to take away from everything that we'll talk to you about today, advisors working in a private client space, private wealth space, really need to, as a result of this consultation, be identifying people in a cohabiting relationship a lot earlier, so that those people can be made aware of these changes and how it might impact them, because it's big.
Okay, so the top highlights from the cohabitation section of the consultation, and the biggest one is that for the very first time, there is going to be a clear statutory framework aimed and specifically designed for these couples. What we've got at the moment is a bit of a hodgepodge, frankly, of bits of legislation that have come in over time, some from hundreds of years ago, pulling in trust principles, property law principles that weren't ever really designed for those in cohabiting couples. So this is about putting in place a very specific framework for that group of people, which we've already talked about is a huge number of couples in our country. And it focuses on what those couples need come the end of a relationship, rather than what the focus at the moment is, which is on who legally owns what and where do assets sit.
Yeah, and the consultation is currently on quite a wide basis. It repeatedly says that people in cohabiting relationships won't necessarily be treated the same as those in married relationships, divorcing, but our concern is where it is driven by need, it will be very difficult to cross-check that because needs will out. The biggest thing for people to be aware of, your clients to be aware of, members of the public to be aware of, is that that statutory framework will be an automatic opt-in. Currently, the proposal is that that opts in automatically after 3 years, but we've discussed that actually there's quite a lot of legislation that opts people in at 2 years in intestacy, etc. So that could become shorter, and we'll await the government response on that. But people must be aware that it's going to automatically opt in, because so that they know that they can automatically opt out, and importantly, there will be no minimum period of cohabitation where a child's born in the relationship.
And for the children point, that's the case whether or not that child was planned and whether or not that couple have an ongoing relationship. Just the fact of them having children together will automatically opt them in under this new statutory framework. We also, it will move a shift away from where we're at the moment. So in our current advice, when we're talking to couples that aren't married, we get into the real nitty gritty of who paid for what, who bought what, who contributed what financially, because those are the things that give people rights at the moment. That conversation is going to shift, because what the statutory framework will do will look at a couple more holistically. It will look at financial contributions, but it will also look at, well, what's your contribution to your family, your couple, your dynamic? Have you taken time away from work to care for children, to support your partner in running their business? All of that is something that is going to become a much more relevant factor than it is at the moment.
Yeah, so that shift from what do you legally own, or what could you demonstrate that you should fairly legally own or beneficially own, is now turned straight on its head, because it's now going to be driven by need, hardship, and addressing specifically those needs and hardships which have arisen as a result of decisions which have been made within the relationship, which previously has not been a guiding force at any point in Tolata claims, so your property claims, or Schedule 1 claims, which have been solely focused on the needs of children and generally revert back to the paying party. We're now, for the first time, being asked to consider the needs of each party to the cohabiting relationship, irrespective of whether they legally own the property or have contributed to the property or not. And that shift is,
yeah, I mean, it's huge. This whole consultation is the biggest shift. I think it's something that we certainly have been talking about for our entire careers in terms of whether it should be in place. Because it is what is going to happen if the consultation comes in the way that it is suggested it will, is it will entirely reverse the current position on the ground. So people will be opted into the statutory regime. You will have these rights unless you put in place formal documentation with the assistance of legal advice that opts you out of them.
And the drive is to bring the law, I mean, Tolata's 100 years old, even the Children Acts in the 80s, but trying to bring the legislation up to recognising modern families, how people live now. The cost of living means that a lot more people are renting together, people are buying together in a way that they didn't historically. People are living in a raft of different situations and having children in a lot of different family setups. So the law is trying to, or the government is proposing to bring the law up to date. And the way in which they do that has got to focus rightly on the vulnerabilities and people who may be in relationships who aren't able to speak for themselves, advocate for themselves. But overarchingly, every single person needs the same education, don't they? Yeah, you need to be aware of the opt-in.
Yeah, absolutely. And I think that there is a big gap in knowledge at the moment. Whilst there is a huge proportion of the population that thinks common law marriage is a thing, actually, when you delve into the detail of that, they don't really know what they mean by that. They don't really know when it would start to kick in. And actually, for a lot of people, if the noise around the time frame shortening to 2 years does happen, that's not a huge amount of time if this isn't something that's already on your radar.
Absolutely. And I think most family practitioners, most people who contributed to this consultation are so welcoming of the seismic shift that's about to occur.
Yeah.
When, we're not sure, but now that it's been consulted on, I think it's prudent to take it under advisement. But I think ultimately the biggest concern from all practitioners is, how do we get that education piece across? Because we have 47% of the population who still believe in a common law spouse. So the education piece about that has definitely gone awry.
Yeah.
And now we need to hit the ground running to make sure that people are as aware as they can be.
Yeah. And it's those people who perhaps may have already set out their finances in one way, they're planning in one way, thinking, okay, this is the current position. I mean, on the basis of the consultation, all of that planning is going to be massively undone by these changes as and when they come in. So I think thinking not only about the couples in the future that you may come into contact with, but also those that you are working with now, whether they have actively taken the choice not to marry, or whether just through circumstances and life getting busy, that's the situation they find themselves in. This is the opportunity to start having those conversations. And I think there's a huge list of people that need to be aware that this will impact them.
Yeah, that big shift from who legally owns what being the point to what do you both need means that there is a raft of people that we need to have in our mind's eye when we're thinking about who is this law going to impact, what are these changes going to do for them. So people that are living together, obviously, but particularly when somebody owns the house and the other one's residing in it, whether they're paying mortgage or rent or whatever, particularly if there's that arrangement. Somebody now, for the first time ever, who's given up their career to care for their partner or look after children, they are now going to be opted in to having their needs assessed on that basis. Somebody who, or cohabitees who live together but have made unequal contributions, either to the acquisition of a property, the payments going out on a property, other financial products that they might be managing between themselves. If there's that inequality in contribution, they may want to consider whether they opt out. And particularly people who have children but are deliberately unmarried on the basis that they currently know that there are no financial claims between them. If this education doesn't reach them, they'll be labouring under a misinformation, won't they? That their current setup protects them from sharing things that they might not agree to share. So they'll might want to review where they are with things.
Yeah, and that's particularly key if we're talking about people who are in a relationship, perhaps having gone through a divorce or a dissolution of a civil partnership previously, because in those instances, people are much more likely to make an active choice about not entering into another marriage or into another civil partnership, and believe that setup gives them the protections that they need to make sure assets flow to their respective children from previous relationships. And that is now not necessarily the case with these proposed changes. We also need to be thinking about those people who perhaps may have already put in place a cohabitation agreement or a declaration of trust over a particular property, because actually what the consultation is very clear about is that these rights will go broader than property rights. We are talking about potentially any and all assets. So bank accounts, savings, investments, pensions. There are also income claims, so the equivalent of spousal maintenance for cohabitees.
So that's a really important point, isn't it? Actually, the government are currently consulting on the financial remedy claims being as wide in terms of everything that it includes as people who are married. It will include property adjustment, lump sums, pension sharing, income needs claims, although there's discussion within the consultation that will be based on basic needs rather than anything additional. But even where it's interpreted in a more narrow sense, the raft of claims are the same.
Yeah. And if you've already got an agreement, but it's only limited to one property, say the house that you are living in, then at the moment, what is not clear at all anywhere in the consultation is whether you are going to be able to have a partial opt-out agreement where you could say, okay, well, we're happy to deal with all of our claims in respect of all of these other assets, but on this particular property or on this business or on this, money that I have inherited, we are going to do something different. I would think that's probably going to be possible because you can have that in terms of nuptial agreements at the moment, but we don't know. And at the moment, to have that arrangement for a nuptial agreement, the document itself needs to make it very clear that the couple understand that they have broader claims, but have actively made the decision only to deal with this aspect. And that wording will not be in any document that's been prepared before now, because it didn't need to be. So even if clients have got those kinds of documents in place, they are going to need to be looked at. They are going to probably need to at least have that amendment, if not in most cases, actually put down what people want to deal with in terms of the wider asset pool and the potential income claims that are coming in.
Because we discussed, I think, now that even though this isn't law yet, this is a proposed raft of changes, we discussed that actually now that it's there, the proposals have been made, the most prudent approach would be to incorporate it as if it is coming in, reference it in all your agreements, signpost everyone who may fall into these types of categories.
Yeah, and to not rely on potential other structures. So yes, you can put things within a corporate structure. Yes, you can put things within a trust structure, but those structures in and of themselves are probably not going to be sufficient to just ring fence whatever assets are within them from potential claims, particularly if in the kind of course of day-to-day life, the couple are able to just draw on those assets whenever they wish to. They've still got sort of control on how they're accessed and how they're utilised. They are just going to be looked at as an available resource and brought into the discussions.
I think anything that's been put in place prior to this consultation could no longer be considered a silver bullet of protection. I think all protection documents, any planning that's come before now, needs to be reviewed.
Yeah, I think the other big class of people to have a think about are those that are looking to do wealth planning and perhaps pass down the generations. So these reforms may not be affecting them, but actually they may well be affecting the children, the grandchildren, the great-grandchildren that they are looking to pass wealth down to, and making sure as part of having those conversations as a family, you are also talking about what protections do we want there to be in place, and empowering that up and coming generation to know about these changes and to know about the things that they can do.
Yeah, having those discussions, having things out in the open about financial planning at all levels of the family and anybody else that sort of falls into those categories of receiving gifts with succession planning definitely needs to be looped in. I think with everything like this has been a long time in the making. I mean, our entire careers, decades of thought and campaigning has gone into this, and it's been given a considerable amount of thought by all involved. But as with anything new, there's some grey areas that we wanted to highlight as possible areas that might be wider than initially anticipated, maybe some narrower, some that might pull in people that you might not have thought about before. So yeah, the grey areas in this type of consultation. I mean, what is cohabitation? What does that look like? We all know that, particularly in the way that modern families arrange their lives, it's not necessarily we moved in on this date. Sometimes it's a more phased move in. Sometimes people are moving in and out of different places they're renting or they're sofa surfing or whatever. So actually the definition of what cohabitation is and when did that start, I think could cause an area of disagreement, an area of debate between couples that are looking to rely on these claims if and when they come in. Another interesting area, what is romance? What determines a romantic relationship? The consultation says that this is going to be limited to people in sustained romantic relationships, i.e. not family members, not brothers and sisters, not siblings, not landlords and tenants. But what happens when the lines blur between platonic or landlord-tenant relationships? People having to give evidence on that type of thing. There's sort of raft of discussion points that could arise from people that don't sit neatly in we moved in on this date and we started living together on this date and we stopped on this date. I think can be a lot of discussion points.
And it goes broader than the start of a relationship, because that kind of setup is pretty common throughout relationships. We have a very transient population, people moving away to do work for considerable periods of time. You know, if you've got an armed forces family who one of the couple is sent on deployment for 6 to 8 months, how does that impact? Or you've got somebody who, you know, works on an oil rig and is away for 6 months and then back for 6 months. All of these things,
cohabiting?
well, exactly, all of these things are going to need to be looked at. What happens if you've got, you know, a very international family who perhaps have a home here and a home in several other countries around the world and dot themselves about and aren't always living in the same house at the same time? You know, how many nights a week are we talking about having to be in the same property for it to count as cohabiting? The other big thing at the moment is there is nowhere within the consultation that indicates how these changes are going to come into effect and whether they are going to apply retrospectively or not. So if you've got a couple at the moment who are perhaps hitting the year mark, then, you know, it wouldn't be unusual for this type of legislation to take about that long to get into the statute books. Is that going to be sufficient? Are they going to start, or is actually the clock going to start for everybody on the day that the law comes in?
And then you find some people would need to be together for 5 years to make use of the claim. You know, we can't second guess because it's simply not covered. So I think it comes back to that point.
Yeah.
If they're in an unmarried relationship, signpost them, make them aware of this. I don't think there can be any limitation to people that may need advice or may need an overview of it, just to sort of check for themselves, could I fall into it?
Yeah, exactly. And I think the big push at the end of the consultation actually is thinking about how do we get this information out there. So I wouldn't be at all surprised if these legislative changes also come with sort of practical and professional obligations for people broader than family lawyers. So basically anybody who is going to come into contact with a couple at a point at which they may be starting a cohabiting relationship.
Yeah, particularly when they're becoming financially involved together, the purchase of a house, going in on a mortgage together, arranging their finances, you know, making investment decisions together. I think the question has to be, could you fall into a cohabiting relationship category, even if you wouldn't call yourself a couple?
Yeah.
Or even if you maintain separate properties?
Yeah.
Because you have two separate, you know, families from previous relationships. Even where you are structuring everything separately, that is not in itself going to be enough if these proposals come in in the way that they're drafted in the consultation. So headline, if there are people that come across your desk, people that call, people you advise, people that you work with who are in any form of unmarried relationship, let them know about the consultation. Put them in touch with a family law practitioner so that they can get the advice, make their informed decisions, and decide whether they consent to these changes on an automatic opt-in basis or not.
Yeah, and that's something that can be happening right now, because the opt-out agreements, as they're being called in the consultation, what we would have referred to previously as cohabitation agreements, can be put in place now. Can reference the changes that are likely to come in, can reference the consultation, and can make sure those protections are there as and when the legislation comes in.
Yeah, because I think importantly, as family practitioners, we tend to see people when things have already gone wrong. And we would love the opportunity to give that advice at the beginning, so people are making informed choices about how they arrange their finances, how they arrange their family life, and what protection documents they can put in place at the beginning so that they can rest easy, knowing that their documentation reflects how they both want to organise their lives. So yeah, I think as a starting point, what can we do? What can you guys do now? Have a quick review of all your clients and people that fall within their category of beneficiaries, you know, children, other people they might leave gifts to. Don't wait for them to let you know that they're in a couple. Make those inquiries, be interested in their arrangements, and absolutely, if they have children, put them in touch. Invite them to get the advice. They can't get the advice if they don't know about it.
Yeah, it's also going to need to be really important that we've got some really clear records of assets being purchased, how they're being purchased, what the intentions were around those. You know, the obvious thing is conveyancers making sure that anybody purchasing who is not in a marriage or in a civil partnership is referred on to a family law practitioner, so that we can go through the implications of this with them. Because, as I say, it's going to impact much more broadly than just on that property, but that's a great touch point for making sure that those couples are aware of those situations.
Anybody who already has a cohabitation agreement in place, or a prenup in place, or a postnup in place, in light of the proposals in this consultation, really needs to have it reviewed, because there will be tweaks, amends, changes that need to be made to each 3 of those documents to make sure that it still works for them, because it would be awful if it got forgotten about and this consultation becomes law, and then all of a sudden they have a prenup, a postnup, or a cohab that doesn't do what they thought it did.
And I guess the other big takeaway for you right now is to recognise just how important your files and your notes may become. I mean, you know, at the moment when we are advising cohabiting couples, we are asking for conveyancing files. With these changes coming in, we are going to be looking much more broadly for anything that might give us an indication or some evidence about what this couple was thinking and planning for at the time. So if you are a mortgage broker or you're a financial advisor, your file, your notes from your annual review meetings with this couple are going to become critical. So
Really
making
important.
sure you've got a really great note of, you know, this is what they told me, this is why they want things structured like this. You know, even better, I flagged and signposted that these changes will impact probably, and they need to get some advice on this. You know, you want to be protecting yourself as well moving forward. That all of that is going to be really good, important information to this couple moving forward, and perhaps thinking about, you know, how long are you keeping this information for, and in what format? You know, is it all handwritten? Are we typing it? Are we keeping it electronically? How long are you doing that? Do your clients know how long you are keeping their data for? Because all of that could become a relevant consideration.
Are they being given copies?
Have they been given copies of everything? Does the summary that you give them of your meeting pull out what will now be these really key points? Because if it doesn't already, it absolutely should do from this point on.
Definitely. And I think we've had the consultation, everyone's been invited to give their views. That's now closed. We await the government response. The consultation, I think, says that they'll release that response as soon as reasonably practicable or something. So we don't know when the next step of this process will occur, and we don't know what their full response will be. But even though it's not yet law, it's very much destined for that end point. And so it's prudent at this stage to incorporate what we know at this early juncture into all asset protection, all family planning, any big decision that people are making that could fall into this category of people. And we've done a huge whistle-stop tour, haven't we? Cantered through that. But if anyone has got any comments or questions or queries, or wanted to have, you know, a quick chat about anything, then just drop us a note in the comments, and Zoe and I will follow up with you directly.
Yeah, and if you've enjoyed these sessions, they are a regular thing from nights, not just from Hannah and I, across all of the different practice areas that we cover here within the business. So if there are other areas that might be of interest to you, then just click through into the Knights LinkedIn page. You can see the historic insights that have been given. There's a lot on there around the changes on employment law at the moment, and there will be future ones coming up. I'm sure you will hear from Hannah and I again when the government response is available. And as Hannah has said, if you've got any queries or any questions, whether it's personal to you or potentially to your clients, to your family, to your friends, pick up the phone. We're very happy to have some conversations with people. But it's been a pleasure this morning. Hopefully it's been helpful, if not a bit of a whistle-stop tour. And we'll leave you to enjoy the rest of your day.
Thanks for listening. Have a good day.